Welcome to the Peak and Northern Footpath Society's online talks. In this talk, Rhoda Barnett will explain the work of the Courts and Inquiries Committee and how PNFS uses the law to protect public access. Rhoda Barnett is one of our most experienced Courts and Inquiries officers and represents the Society over much of Derbyshire. She was Principal Rights-of-Way Officer at Berkshire, and she continues to provide consultancy on rights-of-way outside the PNFS region. For PNFS, she advises members, inspectors and trustees on rights-of-way law.
Right, now you will notice that there is a very pale background to this first slide. And if I go on to the next slide, you will see what that pale background actually is. It is an extract from the definitive map for Derbyshire. And the reason why I've used it as the background slide is that it is so important. The definitive map and statement underlie all the work which the Courts and Inquiries officers do. So I thought I'd put it there just to remind you all. This is actually a paper map. The maps which you see on the online mapping, if you look at your Highway Authority online mapping, is in fact an interpretation of the definitive map. This is the real definitive map. And in the case of Derbyshire, it is rather old, in the 1960s, in fact. Some of your highway authorities, I think, will have much newer maps. Just a brief bit about the Constitution. The Courts and Inquiries Committee is here because of the Constitution, and it is in paragraph 4 of that Constitution which sets out what Peak and Northern's does. And in particular, number 1A, the objects of the society, which simply means the aims, the objectives, creating, preserving and improving open spaces. And it is particularly the preserving which we are involved with. And also preventing, can somebody mute?
Yeah, I've done that.
And also preventing the abuse of public rights. That is our function. There are also 2 other paragraphs in the Constitution, 1C and paragraph 2. 1C gives us our reason, our objective for dealing with public path orders, creation, closure, diversion, and so on. And paragraph 2 states that the way in which Courts and Inquiries officers work is by negotiation, but always, if necessary, we will also take legal action. Another paragraph is paragraph 31 of the Constitution. This gives the authority to the Management Committee to delegate its powers, and its powers of protection, the legal protection of public rights of way, are delegated to the Courts and Inquiries officers. But we don't have any right to initiate the spending of money. It has to be the trustees, the Management Committee, which agrees to us actually spending money. And the Courts and Inquiries Committee is established in accordance with paragraph 31. Right, who is on the Courts and Inquiries Committee? First of all, there are trustees. There has to be on the committee, members of the committee, a minimum of 2 trustees, usually including the Society's chair. And ever since I've been on the Courts and Inquiries Committee, the Society's chair has always been a member, and except when they're on holiday or away, chairs the meetings of the committee. Also, of course, there are the Courts and Inquiries officers, and these are members of the Society who have been authorised by the trustees. So we get our power to do the things we do from the trustees. We are authorised to represent the Society. There's also a gentleman called the Consultations and Orders Manager, because unfortunately we don't have complete coverage, far from complete coverage of our area, with these area officers who evaluate diversion orders and do several other things as well. And so there is a consultation and orders manager based at Taylor House who covers the areas which do not have an area officer. And there are other people who invited to attend as observers, and they can speak, and lots of these other people who come, they do speak, certainly, and very valuable speaking, but they have to be invited to speak by the chair. Courts and Inquiries Officers, where do they come from? They are appointed by the trustees, but the Courts and Inquiries Committee actually recommends to the trustees people which we think are suitable, have the expertise and the knowledge to be Courts and Inquiries Officer. And any potential Courts and Inquiries Officer, first of all, observes the meetings. 2 years ago, I would have said come to the meetings, but of course all our meetings have been on Zoom for the past nearly 2 years. So they observe a meeting. They have to decide, obviously, if they want to be a Courts and Inquiries Officer, and we have to decide if we think they are suitable to be one. But even someone who perhaps at the time isn't completely suitable, if we can recognize the potential, then we can appoint them. They will have induction, they will have training. If necessary, they will have a mentor. So somebody who is experienced will be mentoring any new Courts and Inquiries Officer. And then lastly on this slide, we need more. We are very short of Courts and Inquiries Officers. There are large areas of the Peak and Northern area who are not covered by Peak and Northern, by Courts and Inquiries Officer. So if anybody here thinks that they might like, having seen this presentation, they might like to do this, then do let us know. Meetings of the Courts and Inquiries Committee, we meet a minimum of 4 times a year. That's in our terms of reference. Normally it's 6 a year, so every other month. The meetings are chaired by the Society's chair, a trustee or a Courts and Inquiries Officer. We have, obviously, being a constituted committee, a quorum, and the quorum for making decision is 2 trustees and 2 Courts and Inquiries Officers. And if the decision are not unanimous, they are made by a majority of members. But if there is a trustee who doesn't agree with what we are deciding, then the decision is then referred to the next meeting of the trustees. So always we act under the authority of the trustees. Obviously, being a committee, we have a proper agenda and we have minutes. The agenda is compiled by the Society's secretary, but of course the Courts and Inquiries Officers always say what they want to be on the agenda, as well as the secretary deciding. Minutes of the meetings are official minutes which are approved by the next meeting of the Courts and Inquiries Committee. And all of this lot, the minutes, any reports to the committee are placed on the volunteers area. So if any of you ever want to look at these documents, I understand that David Gosling has to give you a username and a password so you can get into the volunteers site. Should I say, David, how you do that, or?
If people can contact me, then we can deal with that.
Yeah.
If they already have an entry to the FID, then it's the same for the volunteers area. Right,
yes. So you can go through the website and you can actually read what the Courts and Inquiries Committee has been doing. Just very simply, the agenda for the meeting, which was held on the 1st of October, the normal things which you have with meetings: welcome, apologies, minutes of the previous meeting. We have an action log to remind us all of what it is we have agreed to do and make sure that we do it. We've been revising our terms of reference just quite recently. We revise them quite frequently because things do change. We had a new gentleman called David Taylor, who we decided to appoint as a Courts and Inquiries Officer for part of Wigan. And then the Courts and Inquiries Officers submit reports. at that meeting, 5 of us did submit reports which were discussed by the committee. We, as a committee, we make recommendations to the trustees. These encompass appointing new courts and inquiries officers and area officers. If we wish to begin court proceedings against a local highway authority or a landowner, then we do have to recommend to the trustees that we do this, and the trustees have to authorize us to take these court proceedings. And also we recommend the trustees to adopt new policies and revision of old policies and the revision of the volunteers handbook and any other actions which have potential to need society funding. So anything which looks as though it might develop into something serious enough to need serious money spending on it, then the trustees have to approve it. We also give advice to the trustees, responding to consultations, advice on any other matter which the trustees require. And Section 31(4) of the Constitution means that we have to report all our actions to the trustees, and we do that by means of discussing our minutes. The minutes of the Courts and Inquiries Committee meeting are discussed at the trustee meetings. Right, that's sort of really the brief background of what's the Courts and Inquiries Committee, why it's there. What do we actually do? Well, first of all, we give advice all the time. All the Courts and Inquiries officers are always giving everybody who wants it advice. In particular, of course, we give advice to inspectors, particularly new inspectors, but also the more experienced inspectors often need advice as well. How to report to highway authorities, how to interpret the law, how to assess. It says 1,001 other issues. I'm constantly amazed at the things which we need to give advice about. We also give advice to other Peak and Northern members, highway authority officers. You will be amazed at the number of times that highway authority officers and particularly district council officers don't actually know what they're doing. So we advise them. Landowners, parish council, developers, anybody who has anything to do with public rights of way, we can offer and give them advice. It is obviously much better that all these people do know what they are doing, because what they do affects the users, affects walkers, and it's very important that they are getting it right. Right, so that's the first thing we do, we give advice. The second thing we do is we deal with faults on the public rights of way network. We receive reports from inspectors and from members of the public about faults on public rights of way. We are concerned nearly always with serious faults because, as you can appreciate, there are just so many faults out there that we couldn't possibly get involved in detail of minor faults. But any fault which is serious, and the criteria for being serious I have listed there, we will get involved with. If we consider a fault is serious, we will contact the relevant highway authority and we will discuss the fault with either the rights of way officer or the rights of way manager. We receive, we've done that one. Oh, sorry, the bottom one. If we, having discussed it with the manager, we don't get an assurance that the fault is going to be remedied, we can seek the authority of the Courts and Inquiry Committee to send what we call a letter before action. And then if it's necessary, in other words, if the fault is still not resolved, we can serve one of two different kinds of legal notices, Section 56 notice or a Section 130A notices. And these are actually sections in the Highways Act 1980. First of all, if we look at the Section 56 notices, I have to show these pictures because I love them so much. The left-hand one, this is a byway open to all traffic, a boat in the village where I live. And you can see what it was like when I did actually serve a notice on the county council, because a public right-of-way has to be fit for the use which is made of it. And this is obviously not fit for people walking, and was not fit even for the dog in the background. He didn't like it very much either. So I served a section 56 notice on the council, and lo and behold, they very quickly repaired it. And that was how that same section looked after it had been repaired. It was about a mile long. They spent an awful lot of money on it, but they did a tremendously good job. And now, in fact, it has merged a lot better in with the surroundings. There's actually a strip of grass down the middle. Vehicles use it, but they don't use the middle strip. So that's how it's developed. And they made a really good job of it, all because a section 56 notice was served on them. And a bit more about these section 56 notices, because they are very important. The underlying thing about these is that the Highway Authority has a duty to maintain highways which are publicly maintainable. Now, all public rights of way on the definitive map are highways, but they are not all publicly maintainable. The vast majority are, but not all of them. If the public rights of way are publicly maintainable, then the standard of repair which has to be met is actually, in law, it is a lawful standard, is that the way is reasonably passable for the ordinary traffic of the neighbourhood at all seasons of the year. And if anybody thinks that a way is out of repair, in other words, it is not suitable for ordinary traffic of the neighbourhood at all times of year, anybody, and the Peak and Northern Footpath Society is one of these bodies, called a complainant, can serve a section 56 notice on the Highway Authority. And what the authority has to do is they have to respond to that notice within a month. They have to admit that the way is a public way and that it is publicly maintainable, of course, only if that does apply. And within 6 months of the admission, if the complainant is not happy that the path had been repaired, then the complainant can apply to the magistrate's court. And the magistrate's court, if they agree that it's not in proper repair, can make an order requiring the authority to put the way into proper repair. This is a very powerful legal provision which the courts and inquiries officers can use, and they do use. A few more points about it. The lack of resources is not a valid defence. Now, highway authorities at the moment are very strapped for cash, for resources, staff, and so on. But if a section 56 notice is served on them, they cannot use that as an excuse. And that, of course, does make it a very powerful weapon in our hands. But if the court makes an order, the complainant can get their own costs back. But if the complainant is unsuccessful, in other words, if the Peak and Northern Footpath Society goes to the court, but the court does not agree to make an order, then there's a possibility that not only would they have to pay their own costs, they also have to pay the costs of the authority. So, of course, this is not something which we can use willy-nilly. We have to be absolutely certain that we are serving a Section 56 notice correctly, because it can have very large cost implications. And so, of course, we have to prioritise where we serve notices. I mean, it must be at least a quarter of the paths in the whole of our area are out of repair. We cannot serve notices for all of them. So we have to prioritise notices. And our priority scheme is always to get the paths which are most benefit to walkers, to get them repaired. But quite often, it's just sufficient to warn the authority a notice will be served, or even to serve the notice, but not get as far as the magistrate court, because the authority will, when it receives the notice or it receives a threat of a notice, will actually go out and do the work. And in fact, as far as I know, I don't think Pecan Northern has actually ever gone to the magistrate's court. It's never been necessary. The threat of the notice or the actual notice is powerful enough to make them do the work. Section 130A notices, the other type of notice we can serve, are to do with obstructions. Now this path here, the footpath, you can see the arrow, can you? David, can you just confirm that you can see the yellow arrow? No. Oh.
Oh, your cursor?
Yes.
Yes, we can see that now.
Right, okay, because what I just want to point out is where the legal line of this path goes. It goes along there, it goes through the wall, it goes through that gate, and it goes off there. So it is very obvious that this wall is blocking the legal line of the path. Now, in fact, there is an alternative, which is up these steps here, over the wall, across this field. Oh, sorry, I have to go back. Across that field and through that stile there, and then round to join the legal line. So in this case, there is an alternative. It's not particularly good because it's rather a high wall, and if you know, a little bit lack mobility, it's a bit difficult. There is an alternative. So normally this, in fact, would be a lower priority because of that. But if I show you where this path actually runs, it's this path here, which is footpath 5 Grindlow. It goes along there. That's where the photograph was taken. And you can see the legal line of the path, the dotted purple line, goes through that wall. And then the path goes up and around there and around there. But then you can see what happens here. This is a ghastly situation. Footpath 5 is blocked. These are buildings. Footpath 5 is blocked. Footpath 4 is blocked. Footpath 3 is blocked. They are all blocked by buildings. So you might say, well, why don't you serve a legal notice, a section 130A notice, because these three paths are all blocked. And the problem is that we cannot, nobody can, serve a notice because a path is blocked by a building. That is actually in the legislation. And if I show you on the next one, anyone who alleges that a public right-of-way is obstructed, unless the obstruction is a building, may serve a notice. So when this legislation was prepared, which was in the Countryside and Rights of Way Act 2000, a path blocked by a building was excluded. So what I am actually considering with this is serving a section 130A notice for the little wall which is blocking the path, hoping that the council will take this seriously and therefore will divert these paths, will deal with the diversion. So a section 130A notice to deal with the wall is in fact a sprat to catch a mackerel, or whatever the expression is. I hope that they will go on to do bigger things. If a section 130A notice is served, what the authority has to do is to serve notice on the person responsible for the obstruction, saying what action it's going to take. So within 1 month, which is quite a short time period, the authority has to serve a notice on the person who is causing the obstruction. 2 months after the serving of the notice, the complainant can go to the court. They have to tell the authority that they are about to go to the court. They can go to the court, and the court, they can, within 6 months, they can serve a notice that they're to apply to the court. The court would make an order ordering the authority to remove the obstruction. But this one is certainly not a straightforward process. It's much more difficult than serving a Section 56 notice. First of all, the obstruction has to significantly interfere with the exercise of the public's rights. That doesn't mean it has to block the whole width, but if an obstruction narrows the path down such that it's difficult for a user to use the path, then that is a criterion for serving the notice. It mustn't be seriously disputed that the way is a public right of way. And this is a bit of a landowner get out of jail clause, because as soon as he realizes this and he's getting the advice of a solicitor, he can actually dispute that it's a right of way. And he'd have to try and find some evidence for this, but this can hold the whole process up. And the authority has a defense against this, which is saying that having regard to the number and seriousness of obstructions in respect of which it has a duty to remove it, the obstruction will be removed within a reasonable time. And in other cases, again, Peak and Northern have not ever served one of these notices, but in cases where they have been served by other people, this is often where it all falls down, because the highway authority simply says, well, we're doing our best. So this, as I say, is not as easy to serve as a Section 56 notice. Right, what else can we do? We can serve these two notices. What we can also do is take other legal actions. The Peak and Northern Footpath Society, and in fact anybody, can take out a private prosecution. If a path is obstructed, then we could privately prosecute the landowner or the occupier who's responsible for that obstruction. We can also take what's called a judicial review. We can review a highway authority's decision. If a highway authority decides not to remove an obstruction, we could, in theory, carry out a judicial review of that. We could also seek injunctions, a legal injunction to prevent an action which might injure the public. But the problem with all of these is that they are potentially very expensive. They would need us to employ a solicitor or a barrister. And in fact, again, as far as I know, none of these have ever been done. I don't know anybody who's been in Peak and Northern longer than me could agree with that. But because the costs are so risky that you will be landed with an enormous bill, we try and do other things first. Going right back to the very beginning, we try negotiation rather than taking legal action. This is very much a last resort. Okay, so that's how we deal with faults, but courts and inquiries officers have also got a lot to do with proposed public path orders, diversion, stopping up or creation, orders made under the Highways Act or under the Town and Country Planning Act. All orders which are made, all legal orders, must meet the relevant legal tests, and these are specified in great detail in the legislation. And what a competent highway authority will do is to consult bodies like Peak and Northern before they actually make an order, because once they have made the order, things get a lot more serious. So they consult us. With one or two exceptions, highway authorities will consult us before an order is made. And at that stage, we can and we are be very helpful. We can help the highway authority to see where perhaps they're going wrong, or we can support them. We can say, yes, that's a jolly good idea, go ahead and do it. But once the pre-order making consultations have been carried out, if they still think it's a good idea, the highway authority can make the order, make the diversion order, the stopping up order, and so on. And Peak and Northern are able to legally, formally object to these orders. They can support them. They can make a representation, which is usually the same as a support, or they can make a holding objection, which could then be removed if whatever Peak and Northern were objecting to was actually resolved by the highway authority. If the Highway Authority makes an order, it receives objections from perhaps Pecan Northern or from the Ramblers or a parish council or an individual, then the Highway Authority has two choices. It can withdraw the order, which is what would normally happen, or they can send the order to the Secretary of State, and the Secretary of State will then appoint an inspector to decide the merits of the order, whether it should be confirmed or not. And Pecan Northern is a statutory, sorry, there's one I missed out at the bottom. And if we decide to, as the Courts and Inquiries Officer, to pursue an objection, then we do need trustee approval for this, because it can involve money. Going to a public inquiry or written representations defending an objection can be expensive, so we need the approval of the trustees. Okay, they're one sort of order. The other sort of legal orders we do deal with are modification orders. And these are very different to the public path diversion stopping up orders. What modification orders do is seek to legally recognize public rights of way which are not already on the definitive map and statement. The definitive map is only conclusive of what is on it. It does not mean that if a path is not shown on it, that it's not a public right of way. In other words, a large number, a very large number of public rights of way are not actually on the definitive map. And what a modification order seeks to do is to put them on a definitive map. And if a highway authority makes one of these orders, Pecan Northern again is a statutory consultee. We have to be consulted. Again, the highway authority, if it is at all competent, will consult us before it makes the order. And usually we would respond to such a consultation by giving any evidence which we had that in fact the path is already a public right of way. This can be documentary evidence, it can be user evidence. Also, we have to consider in the special case of a modification order which seeks to recognize, say, bridleway rights over a public footpath, it is possible for us, if we think that would be a nuisance to the public, if the riding of horses or the riding of a bicycle on a footpath would be a nuisance, then we can say that, and we can then stop the highway authority from converting a footpath into a bridleway. So that's very important. Once the order has been made, in this case, the authority does not have the option of withdrawing the order. So unlike a public path order, which they can withdraw, the highway authority cannot withdraw an objected modification order. It has to be sent to the Secretary of State. And again, if Pecan Northern have made an objection, then we have to pursue that with the Secretary of State. It can be written representations, it can be a hearing, or it can be an inquiry, or we can actually support a modification order at an inquiry. It depends what we think about this particular order. And again, if we do pursue an objection at public inquiry, again, we need the approval of trustees, because quite often we could actually need support of a barrister at the inquiry. Okay, so those are the things which courts and inquiries officers do. How do they go about doing them? Every court and inquiry officer has the option of presenting a report to every courts and inquiries committee meeting if they need to do so. Obviously, if they've got nothing to report, there is no sense in presenting a report. What the courts and inquiries officers actually do with these reports, they can they ask them to authorize action. So any of the things which I've just mentioned about serving a letter before action for a notice, about objecting to a public path order, supporting a modification order. Any of those things are reported to the committee, and they are then authorised or not authorised by the committee. And also Courts and Inquiries officers give updates on their progress. We discuss them at a Courts and Inquiries committee meeting, and this obviously has very great value. Not only does it help the officer presenting the report, it also means that all the Courts and Inquiries officers gain knowledge from discussing these matters. And just a short extract from my report, which I made to the October Courts and Inquiries Committee meeting, discussing the fact that on 3 footpaths in Melbourne, which is in the south of the country, south of the area, south of Ashbourne, there were some problems with locked gates and cattle grids. And I asked for authority to serve a notice on the council for removement of these. And the committee did give me unanimous authority to serve the notices. Another one, I was simply giving an update. There's a footpath in Ripley, which is again fairly near the south of our area, east of the Peak District, that in fact I served a notice on Derbyshire County Council, a section 56 out of repair notice. And what I was doing was updating the committee on what had actually happened. And what did happen was that the county said, okay, we will do something, we will repair this path, but they didn't do it, they didn't repair it. And so I said, right, if it's not repaired, I'm going to court. But in fact, on the 12th of January, I was consulted about a diversion of the path, and I considered that that was good enough for the time being, providing they did consult, and in fact they have consulted. And on the whole, we think that the diversion they're proposing is more or less okay. I'm working very closely with the inspector for Ripley on that one. Okay, just to round this off, just briefly, 2 successes, good things that the Courts and Inquiries Officer has done. The first of these is what is called the BRIDESTONES. Now, this is on the boundary between Cheshire on the left of the map and Staffordshire on the right of the map. And right down here, not quite on the map, there is a historic ancient monument called the BRIDESTONES, which is why this case is always referred to as the BRIDESTONES. Before we got involved with this, on the definitive map of Staffordshire, there was a footpath running down as far as there and then stopping. On the Cheshire side of the boundary, there was a footpath running up to there and then stopping. So this was what was on the definitive map. Now, you can see that that is an absolutely anomalous, stupid situation. Why are the 2 not linked together? And what Peak and Northern was doing was helping to show to Cheshire that in fact they are linked together by a path on the Cheshire side, but this just happened not to be on the definitive map. So we were involved in putting that missing link between these 2 paths onto the definitive map. What in fact we did was we supported the Ramblers, and we do try wherever possible to work very closely with the Ramblers because we do have very similar aims. They made an application to Cheshire County Council to add this path, to formally record this missing link. The County Council declined, and so the Ramblers appealed to the Secretary of State. This is a proper legal process, and the inspector who held the case directed Cheshire County Council to make an order. So even though they didn't want to, they had to make an order. The order received objections from the landowners, and therefore, there was a public inquiry. The whole matter was considered at a public inquiry. And the Ramblers asked us for help, partly because we were much more experienced in these legal actions, and partly because we were prepared to actually pay money to employ a counsel, a barrister that is, to present the case at the inquiry. And a number of us, the Ramblers who actually made the application, and a number of us from Peak and Northern, we actually went to the inquiry, we gave evidence, and we were successful. So we were very, very pleased with that. It's a wonderful path, lovely scenery. I've got this ancient monument on it. And now this valuable path has been legally recognised. It's on the definitive map and it is legally protected. Right, another very great success story is this footpath at Silverdale. Silverdale is in Lancashire. It's up really the most northwest corner of Lancashire, on a promontory which goes out into Morecambe Bay. Before we started getting active with this, you can see the problem. There are private notices on that gate. So walkers could not go through the gate. And in fact, the gate originally was locked. Instead, they were instructed to walk on the public footpath. Now, they were right. This was, most of it, a public footpath on the definitive map. But the problem was very rocky. This is actually just the shore, the edge of the bay. Very rocky, very stony, very slippery, and in fact, at high tide, flooded. And yet this is where the public were supposed to walk. We got involved. We found that there was evidence of use of, I'll go back and just show you on the, before 1993, none of this lot saying private was there, and people just walked straight through there on a lovely, wide, level path. But of course, you can see that it's very close to the house, and the landowners did not like people walking there. So they put up these private notices. They instructed people to walk around the edge. But we found evidence from lots of people that they had actually used the path between the houses, they're called Brown's houses, and the seawall, and collected this evidence on proper user evidence forms. Peak and Northern then decided to apply to Lancashire County Council for them to make a modification order to recognise that path between the houses and the seawall, to recognise it as a public right-of-way. Peak and Northern made out a very good case, lots of evidence that it is a public right-of-way, and the Lancashire County Council officers ran with this, took it up, did a very thorough investigation, wrote a very thorough report, helped by Peak and Northern, took it to their committee of members, councillors of Lancashire County Council, recommending that they make the order, but the committee, for various reasons, which I won't go into in detail because they're not very nice reasons, they decided that the order should not be made. Peak and Northern's response was to appeal to the Secretary of State, which again is a very valuable legal provision which we can make use of. They appealed to the Secretary of State, an inspector was appointed, the inspector heard all evidence from all sides and decided that the order should be made. And so Lancashire County Council were directed to make an order to put this path on the definitive map. So they made the order, but the landowners, not surprisingly, objected. The people who owned Brown houses and owned that land in front of the house, they objected to the public right-of-way passing in front of their house. So an inspector appointed by the Secretary of State heard a public inquiry, and we gave evidence at that public inquiry, along with people who had used the path, and along with showing documentary evidence. We supported the council, which as they had made the order, they did support it. We supported the council. And in April 2019, the inspector did decide that the order should be confirmed. So at the end of this process, there is now legal recognition for that public footpath between the house and the seawall, and people do not have to walk over the rocky foreshore. So that was certainly a very great success. And as I say, without the hard work of the Courts and Inquiries Officer, not me in this case, one of the other Courts and Inquiries Officer, the path would have been lost, but now it has been saved. And that's it.